You might have seen some pretty unsettling news lately about international students here in the U.S.
Yeah, it's been quite concerning.
Suddenly finding their visas, their SEVIS records terminated. It's leaving a lot of people feeling uncertain, about their studies, even if they can stay past March 2025.
Absolutely. And the scale of it, the number of students hit by this, and just the way it seems to be happening, it's creating this real sense of unease.
Exactly. So for this deep dive, we really want to get into the complexities behind these actions, specifically visa revocations and these SEVIS record terminations.
There's a lot to unpack.
It really is. It can seem super dense. So our goal here is give you a clear picture of what's happening, what the fallout could be, and crucially, what rights international students actually have. We've sifted through quite a bit for you: university FAQs, news reports from places like University Herald, the Emory Wheel, legal takes from Cass Law, government briefings.
And looking at it all together, you do wonder if it signals some kind of shift, maybe changing priorities at a policy level regarding international students.
That's a good point. And right in the middle of all this, there was a really significant legal move down in Georgia. April 18th, 2025, a federal judge, Victoria M. Calvert, she issued what's called a temporary restraining order, a TRO, and it ordered the government to reinstate the legal status for 133 students. That feels like a really big moment in this whole unfolding situation.
It really does. And it brings up these, fundamental questions about checks and balances, the executive versus the judiciary and immigration stuff.
Right.
And just how vital the courts are for protecting due process. You could see that TRO as maybe the first sign of a legal check on what IC has been doing recently.
Okay, so to really understand what's going on, we need to get some basics straight. Let's start with the difference between a visa and immigration status. People often mix them up, but they're quite different things, aren't they?
They really are. A visa, think of it mainly as your travel ticket. It's something you get before you come to the U.S., usually a stamp in your passport. Right. And that visa lets you show up at a port of entry, an airport, a border crossing, and ask to come in. But, and this is key, it doesn't actually guarantee you'll be let into the country.
So the visa gets you to the door, but status is what lets you stay inside.
That's a great way to think about it, yeah. Immigration status, that's the official category you're put in after you're admitted. It used to be a little white card, the I-94, now it's mostly electronic.
Right, I've seen those.
And your status is tied directly to why you're here. So for students, F1 or M1 status, maintaining it means following specific rules, like taking a full course load of classes.
And is it possible then for your visa stamp and your passport to expire, but you're still legally here, your status is okay?
Absolutely. That happens all the time. A student's visa might expire after, say, 2 years, but their program is 4 years long. As long as they keep meeting all the requirements of their student status, staying enrolled full-time, making academic progress, their status inside the U.S. remains valid. The visa is just for entry. And it's also important you can only have one immigration status at a time while you're in the U.S.
Got it. That distinction feels really crucial here. Now, we're hearing this term visa revocation a lot. What does that actually mean in practice?
Visa revocation basically means the State Department is canceling the visa document itself. They're saying it's invalid right back to the date it was first issued. It's like it never should have been granted, or circumstances have changed.
And who gets to make that call? Who can revoke a visa?
Primarily, it's consular officers working in U.S. embassies and consulates overseas. The Secretary of State also has the power to do it, sort of at their discretion.
Okay.
Now, there are also some limited situations where immigration officers inside the U.S. can revoke a visa, like if someone gets a green card or if they already have a deportation order against them. But mostly, it's a State Department function happening outside the U.S.
Our sources mention something called the Foreign Affairs Manual, the FAMAM. Does that shed light on why they might revoke a visa?
Yeah, the FAM is like the rule book for consular officers. It gives reasons like maybe the person wasn't actually eligible for that visa type in the first place, or if the physical visa sticker is somehow removed from the passport, or something we're seeing mentioned now, if the person shows up on the ident watch list, maybe because of a DUI conviction within the last 5 years, things like that.
Okay, so visa revocation hits the travel document. Let's switch gears to the SEVIS record termination. First off, what exactly is SEVIS?
Right, SEVIS. That stands for the Student and Exchange Visitor Information System. It's basically a big web-based tracking system.
Tracking students?
Yeah, non-immigrant students. F&M visas and exchange visitors, J visas. The Department of Homeland Security, DHS, uses it to keep tabs on everyone in those categories. It came about after 9/11, really.
Ah.
Its stated goals are sort of twofold. National security, obviously, but also helping to manage the legal entry and stay of these students and visitors.
So it's the central database. What does it mean, then, if a student's SEVIS record gets terminated?
According to the government's own rules, a terminated SEVIS record means the student is considered to be no longer maintaining their F or M student status. They've fallen out of status, basically.
And who usually does the terminating?
Well, historically, in sort of the standard way, it was done by designated school officials, DSOs, at the universities themselves.
The International Student Advisors.
Exactly. And they terminate a record for reasons that make sense, like if a student got expelled or they weren't taking enough classes or maybe they were on OPT, the work authorization after graduation.
Right.
And they didn't report their employment correctly or they just never showed up to start their program, things like that.
Those seem like understandable reasons tied to academics or program roles. But the recent situation is different, isn't it? That's the core issue here.
That is absolutely the core issue. The really big and frankly alarming development is that ICE Immigration and Customs Enforcement, part of DHS, has apparently started directly terminating SEVIS records.
Bypassing the schools.
Bypassing the DSOs, exactly. Going straight into the system and hitting terminate.
And what reasons are being given for ICE doing this directly?
Reports and the legal documents point to mainly 3 reasons ICE has been using. 1, involvement in protest or speech activities.
Wow.
2, having prior arrests or convictions, even if the charges were ultimately dropped or dismissed.
Really? Even if dropped?
That's what's being alleged in some cases, yes. And the third reason, which seems very broad and ties back to our earlier discussion, is something like individual identified in criminal records check and/or has had their visa revoked, SEVIS record has been terminated.
So, under that third one, just having your visa revoked by the State Department could now trigger ICE to terminate your SEVIS record, even if you're still in the U.S. studying.
That appears to be exactly what's happening, and it's a key point in the legal challenges. ICE seems to be linking visa revocation directly to SEVIS termination, effectively deciding that a visa revocation automatically means you've lost your legal status here.
Which, based on what you said earlier, isn't necessarily the case.
Correct. The legal argument is that visa revocation and maintaining legal status within the U.S. are 2 separate things, governed by different parts of the law and different agencies, largely.
Okay. And regardless of who terminates the SEVIS record, the school DSO or ICE, what happens to the student immediately afterwards?
The consequences are serious and they hit right away. First, any authorization to work, whether it's on campus or off campus, like OPT, it's gone. Immediately invalid.
Okay.
Second, if the student leaves the U.S., they cannot use that same SEVIS record to come back. They'd need a whole new one, a new process.
Right.
Third, they could become subject to investigation by ICE, potentially leading to removal proceedings, deportation. And finally, if the student has dependents here, like a spouse or children on F2 visas, their records get terminated too.
It's incredibly disruptive. Which brings us back to these recent actions by ICE that have caused all this alarm. It seems like this direct termination became much more common suddenly.
That's what all the reports suggest. In March 2025, suddenly, dozens of universities started reporting that their international students were getting these SEVIS termination notices, seemingly out of the blue, initiated directly by ICE.
And the numbers are significant.
They seem to be. Some news outlets and advocacy groups have cited figures suggesting over 1,700 students nationwide might have been affected by these kinds of issues around that time.
And one of the biggest complaints we're hearing is about a lack of due process.
Yeah.
What does that actually mean in this situation?
Yeah, due process is central here. The complaint is that many, if not most of these students, had their SEVIS records terminated with absolutely no warning beforehand.
No notice.
No notice, no clear explanation why it was being terminated, and crucially, no chance to see the evidence against them, respond to whatever the allegation was, or challenge the decision before it took effect. That lack of basic fairness, that's the core of the due process argument.
So you could be a student, doing well in your classes, following all the rules you know about.
Exactly.
And suddenly find out your legal basis for being here is just gone.
That's the reality described in many of these reports. Students who were in good academic standing, some literally weeks away from graduation, others on OPT working legally in their fields, suddenly finding their status terminated.
You mentioned Georgia specifically earlier. Were there particular universities where this was happening?
Yes, the reporting and the lawsuit filings mentioned several in Georgia. The University of Georgia, Georgia Tech, Emory University, Kennesaw State University.
So major institutions.
Major institutions, yeah. It shows this wasn't just some isolated glitch at one or two places. It was hitting students across different types of universities in that state, and likely others too.
Which brings us neatly to that legal challenge and the TRO in Georgia. Can you walk us through that lawsuit?
Sure. So seeing what was happening, the ACLU, the American Civil Liberties Union, along with other groups like the Baxter Immigration Law Firm and the National Immigration Project of the National Lawyers Guild, they filed a lawsuit. Yeah. It was filed in the federal court for the Northern District of Georgia, and they were representing 133 specific international students whose SEVIS records had been terminated by ICE.
And what was their legal argument? What laws did they say ICE violated?
Their main arguments were, first, that ICE violated the students' Fifth Amendment right to due process, that basic fairness we just talked about.
Right.
And second, that ICE violated the Administrative Procedure Act, the APA. That's the law that dictates how federal agencies are supposed to operate, make rules, make decisions.
So how do they violate the APA, according to the lawsuit?
The argument was that ICE basically acted outside its legal authority. They didn't follow their own regulations or the established processes, and that their actions were arbitrary and capricious, meaning they weren't based on reasoned decision-making or clear standards. They were just kind of random or unjustified.
And this lawsuit landed in front of Judge Victoria M. Calvert. What did she decide?
She acted pretty quickly. On April 18th, 2025, she granted the plaintiff's request for that temporary restraining order, the TRO.
And what exactly did the TRO force ICE and DHS to do?
It had a couple of key parts. First, it ordered DHS and ICE to reinstate the SEVIS records for all 133 students named in the lawsuit. They had to do it by April 22nd and make it retroactive, as if the records were never terminated back on March 31st.
Wow, okay, so put them back to where they were.
Exactly. And second, it prevented ICE and DHS from using the names or identities of these 133 students for any other purpose outside of defending themselves in this specific lawsuit, sort of protecting them from other negative actions while the case proceeds.
That feels like a pretty strong rebuke, even if temporary. What reasons did Judge Calvert give for granting the TRO? What were her key findings?
She laid out several important points. She found that the students were likely to succeed on the merits of their case, meaning it looked very probable that ICE did exceed its legal authority and that the terminations were unlawful. Crucially, she addressed that link between visa revocation and status. She explicitly stated that visa revocation by the State Department does not automatically mean someone has lost their legal immigration status within the U.S.
Ah, so she agreed with the point you made earlier.
Yes, and therefore, she reasoned, visa revocation alone can't be the sole justification for ICE terminating a SEVIS record for someone who is otherwise maintaining their student status inside the country.
Did she talk about the impact on the students themselves?
She did, very clearly. She recognized the irreparable harm the students were facing. Losing their education, facing deportation, losing scholarships, jobs, the emotional toll, all of that.
Yeah.
And she also balanced that against any potential harm to the government, finding the harm to the students was far greater. Plus, she noted the substantial public interest in making sure government agencies actually follow the law.
Now, you've mentioned it's temporary. A TRO doesn't last forever, right?
Right.
What happens next?
Exactly. A TRO is designed to be a short-term fix to prevent immediate harm while the court can consider things more fully. In this case, it was set for 14 days.
Okay.
Judge Calvert scheduled a hearing for April 24th, 2025, to decide whether to issue a preliminary injunction. That would be a longer-lasting order, keeping the protections in place for these students while the main lawsuit moves forward, which could take months or even years.
So that April 24th hearing is pretty critical then?
Very critical. The TRO provides breathing room, but the preliminary injunction hearing will determine the next phase for these 133 students and potentially signal how the court views the case more broadly.
And looking at that broader picture again, you said potentially over 1,700 students affected nationwide. This Georgia case, while important, only directly covers those 133.
That's right. It's vital to remember this specific TRO only applies to the students named in that lawsuit. But the reasoning behind the TRO, Judge Calvert's findings, that could certainly influence other courts if similar lawsuits are filed elsewhere.
So it could set a precedent.
It could potentially, yes. or at least provide a strong persuasive argument. Lawyers for the students, like the ACLU and Cook-Baxter, have really hammered home the argument that these terminations were unlawful and violated basic due process.
Right.
Judge Calvert's initial ruling seems to agree with that assessment, at least preliminarily, and it reinforces that crucial distinction. The State Department revoking a visa isn't the same thing as DHSIE terminating your SEVIS record and your legal status while you're physically present in the U.S. The court found those aren't automatically linked in the way ICE seem to be treating them.
This is all incredibly helpful for understanding the legal side. Now, thinking about the students themselves. For any international students listening who might be worried or, heaven forbid, actually get approached by ICE, what are their basic rights?
That's a really important question. Knowledge is power here. The key things to remember are, first, you have the right to remain silent. You don't have to answer questions about your immigration status, where you were born, things like that.
Okay.
Remain silent. Second, you have the right to speak to a lawyer before answering any questions. You can say clearly, I wish to speak with my attorney.
Ask for a lawyer.
Yes. Third, if you do have a lawyer and they've filed the proper form with immigration, it's called a Form G-28, Notice of Entry of Appearance as Attorney, you should tell the officer that and provide a copy if you have one.
Okay.
And just a practical tip. It's always a good idea to keep copies of your important immigration documents, passport, visa, I-20, I-94, in a safe place, and maybe give another copy to a trusted friend or family member just in case.
That's really practical advice. And if students or universities or anyone listening wants to learn more or find support, are there good places to turn?
Absolutely. There are quite a few excellent resources. For legal information and potential help, the Penn State Dickinson Law Center for Immigrants' Rights Clinic has resources online. There's also the Higher Ed Immigration Portal. They have a specific Rights and Protections Hub with guidance for both institutions and students. The President's Alliance on Higher Education and Immigration is another great source of info and advocacy.
Okay.
If someone needs to find an immigration lawyer, AAA, the American Immigration Lawyers Association, has an online referral service.
Hey, got it.
Many universities also have dedicated international student offices, like Penn State Global, offering support and resources. And for ongoing regulatory updates, NAFSA, Association of International Educators, is the main professional organization in the field. We can definitely put links to all of these in the show notes for you.
Perfect. That sounds incredibly useful. Yeah. So as we kind of wrap up this deep dive, what are the main things you think we should take away from all this?
Well, I think the big picture is that the situation for international students in the U.S. right now is pretty complicated and definitely evolving. These recent ICE actions involving direct SEVIS terminations have raised some really serious legal and ethical flags, especially around due process. The Georgia TRO is a significant development. It provides real, albeit temporary, relief for those 133 students, and it challenges the legality of ICE's approach. But the broader issue isn't resolved yet.
Right.
And understanding that core difference, visa for travel, status for staying legally, and how SEVIS fits into that, it's just become absolutely critical for students and schools alike.
You've definitely helped us get a much clearer handle on what's a really complex and frankly concerning issue. It feels less overwhelming now, understanding the pieces. So maybe a final thought for everyone listening to chew on.
Okay.
When we see these kinds of widespread disruptions happening to international students, people who've come here to learn, often at great expense and effort, what does that really say about the U.S.'s image as a welcoming place for global education? And maybe more fundamentally, about its commitment to basic fairness and due process under the law. It makes you think about the ripple effects, doesn't it, for international relations, academic freedom?
That's a powerful question to end on. It really forces you to consider the bigger implications. Maybe for you listening, the next step could be checking out some of those resources we mentioned, or keeping an eye on the news around that preliminary injunction hearing on April 24th. Or perhaps just, talking to international students you might know, hearing their perspective on all this.